Wait, please. Malas, I am relying on the judgment of Honorable Supreme Court 2014, Volume 3, SCC 394, Paragraph 12, Malas, which affirms the judgment in the Gujarat, Malas, Meghji Bhai, Khimji Veera versus Chatur Bhai, Talja Bhai, wherein it has been held that all the legal representatives, whoever suffers, has to be compensated under the MV Act, my lords, because the principle obedience sibi remedium will be applicable wherever there is a violation of a right. There should be a remedy. And my lords, in the evidence before the learned court below, my lords, these people, the brothers had specifically stated that they have suffered due to the death of the brother, my lords, who was supporting them financially. And secondly, my lords, this issue was not raised by the appellants, my lords, before the learned court below. So, my lords, I am disputing that they are taking this issue now before this honorable court, my lords. In appeal, they cannot raise this issue, my lord, because it will be again they had to lead evidence and they had to show that how they are not the dependents or they have not suffered, because specifically my witnesses have stated that they have suffered.
This is the appeal by the
2014, Volume 3, SCC 394.
appeal by
This appeal is by the insurance company.
future prospect has not been given.
Future prospect has not been given, my lord.
Where is Mr. Ashutosh Anand? You have been paid any amounts? What is LCR?
How much they have paid, I'm not sure, because 50,000 was initially paid, but thereafter I don't know. I'm not sure.
All the low court records. All for the low court records. Under the heading for hearing, serial number 37, MA number 224 of 50, Mr. Arvind Kumar Lal for appellant, Mr. Sunil Kumar, Mr. Rohit Ranjan Sinha.
This appeal to management, my lord, the vehicle is not insured. The vehicle is not insured.
The vehicle was not insured.
Not insured. So, Honor has already appeared in this case, my lord.
This is for enhancement.
Yes, my lord.
My lord, I, on behalf of opposite party number 2 and 4, रोहित रंजन सिन्हा आर्ग्यू काउंसिल हैं, उनकी माँ का आंख का ऑपरेशन हुआ है, तो मैंने उसी में है आज, इसमें थोड़ा हमको टाइम चाहिए था.
Rohit Ranjan Sinha is appearing on behalf of
OP number 2 and 4.
who are they?
Vehicle owner and vehicle driver. One of the vehicle owner.
No. The award is against whom? Both.
Jointly.
Okay.
Let it be taken up on Monday or Tuesday, my lord.
Tuesday? Tuesday is a holiday. Monday?
My lord.
आप समर वेकेशन कर दिए जाए.
Na? Wait. With the amount?
Pay the entire amount, deposit the entire amount. On the request, on the prayer made to the council for the appellants, electricity on 2nd May.
Serial number 38, MN number 293 Mr. Arvind Kumar, Mr. Alokal, corresponding.
In this case, my lord, earlier this case was for injury claim, and during pendency of the claim application, the injured person died, my lord, and therefore his legal heirs were substituted in this case. Although the reason of death is not, there is no nexus between the injury and the death, my lord. After 7-8 years, he died,
He has to receive the amount of injury.
my lord.
The amount of compensation arise because of the injury.
That has been paid.
No paid, not paid.
Yes,
Not
As
prefer-
per my instruction, as on today, no payment has been made.
Okay, I'll seek instruction whether it has been paid or not.
uh,
I'll see to it.
he is praying for enhancement.
He's praying for enhancement. Yes.
On that ground,
It
what
can
are
be
the-
enhanced only on account of the injuries.
Yes, it cannot be
Yes.
converted into a death case.
Yes, that is the
I'm not saying it is a death case.
yes.
He's also
There is no
not, he's
nexus
also not
between the
saying.
death and
He very
Yes.
fairly stated that though he died after 7 years, there is no connection of death and this
Madam.
accident. He said that, Mr. Lokla. Yes, Mr. Arvind Lal, what is the ground for enhancement?
My lord, in this case, my lord, he was 5,000 rupees was the income, 60,000 per annum. He was working as agent of buses, and his income has not been taken into consideration, my lord. And although I have taken the ground of funeral expenses, etc., but that is not tenable, my lord. So entire future career was disturbed.
What is the
Therefore,
nature?
this can be settled, my lord. This can be settled.
He was paid how much? 1,35,000.
1,35,000 was the award.
It can be
Not
settled.
paid till date.
It can be settled.
Yes, my lord.
The parties submit that the matter can be settled in a Lok Adalat, full stop. Considering their submission, list this.
Because I'm afraid of my learned friend. At least he must disclose what should I quote to my client. Kitna? How much?
Where is the question of fearing? I am just saying it. No payment has been made.
That
You
is
please
true, but
verify it from your client.
what is the expected amount?
The National Lok Adalat.
I will tell you. Lok Adalat mein. In injury cases, my lord, I must say that one should not be allowed to make fortune out of misfortune. Fair amount has to be given, just amount.
In not only in injury
Not be
cases,
bonanza.
all cases.
Although I am for the claim.
Yes. Just see, it can be resolved.
It can be resolved.
Yes,
It can be resolved.
At
can
least
be
three
resolved.
cases I have been able to send for the Lok Adalat. One is to be decided by your lordship. One is to be decided by your lordship, in which Mr. S.J. Roy was appearing apportionment
Yes.
and right of recovery that cannot be settled in the Lok Adalat, but that has to be
No,
decided by your
the Jalsa will not insist on sending the matters to the Lok Adalat where there is a right to recovery has been granted.
Yes, madam. That is
But if the owner appears and they agree, then it can be settled.
then there is no dispute. Then
I
we
have,
can.
I have instructed, I have given direction to Jalsa.
Okay. So kind of your lordship. Yes, they are very much afraid of my officers. They are
No,
if they
no.
wanted.
And if any letter has to be written, Jalsa will write those letters taking the lawyers in confidence.
In fact, my officers they wanted to meet your lordship in this matter.
I have directed Jalsa. They will consult the lawyers, and they only in those cases the letter will be sent.
Yes, that would be fair.
Serial number 39, MN number 466 of 15, with serial number 30, 43 of 21. Mr. Arvind Kumar for appealing in first case, Mr. Vikas Sinha for appealing in second case.
Vehicle not insured.
But no, liability was saddled upon me on the ground that the deceased was gratuitous passenger.
Then it has
But
to be
it's, yes, it has to be.
Let us, we are here to decide. Let
Yes,
us read the evidence. What is
my
the
lords,
evidence?
first of all, my lords may come to running page 10, which is of the memo of appeal. The manner of accident is that
Manner
the
of
deceased,
FIR.
yes, my lords, the FIR is,
When we have the FIR, where should we go to the
but
second?
in as per FIR, it was lost by one Gopal Manjhi. He says in the FIR,
Read that.
हमारा नाम गोपाल मांझी, उम्र करीब 27 वर्ष, साकिन बस्ता कोला, थाना झरिया, जिला धनबाद का रहने वाला हूँ. हम आज दिनांक 9/6/2009 को 4:30 बजे आप ईस्ट बासुरिया कतरास थाना के पुलिस पदाधिकारी के समक्ष बयान देता हूं कि हम तथा हमारे साथ करीब 25-26 व्यक्ति को लेकर, काइंडली मार्क दिस लाइन में लॉर्ड्स, 25-26 व्यक्ति को लेकर ठेकेदार नंदलाल दत्ता, पिता नामालूम, साखिन बासुरिया थाना बैंक मोड़, जिला धनबाद में पूजा कैटरर में खाना बनाने एवं बर्तन धोने के लिए धनबाद से दिनांक 7/6/2009 को संध्या करीब 7 बजे 407 गाड़ी नंबर JH01D 6776 से कतरास लाए. पार्टी समाप्ति के बाद हम सभी उसी गाड़ी से दिनांक 9/6/2009 को वापस 3 बजे भोर में कतरास से धनबाद के लिए चले. जैसे ही हम लोग हरीक रोड काड़ा माड़ा पुल के समीप 4 बजे भोर करीब पहुंचे कि उक्त गाड़ी चालक के तेजी व लापरवाही से गाड़ी चलाने के कारण गाड़ी हरीक रोड पर ही पलट खा गई, जिससे हम सभी गाड़ी के नीचे गिर गए तथा गिरने के कारण हम कहीं गंभीर चोट लगा तथा हम सभी को किसी को गंभीर चोट लगा तथा किसी को हल्की चोट आई. इसलिए
आगे पढ़ने का जरूरत नहीं है.
हाँ, तो एज पर FIR,
Who are you?
I am the owner. I am the owner, and I say that this FIR was lodged with an averment that there are 20-25 persons who used that vehicle, went to the place for the purpose of catering, and while coming out on the same vehicle, the vehicle turned turtle. One of the person has died. His legal heirs have filed claim application. Now, relying on the content of this FIR, the tribunal has made a finding that the deceased was a gratuitous passenger in view of this 20-25 persons stated in the FIR, and therefore liability is fastened upon the owner of the vehicle. Now, my lords, first thing I have to say that the Honorable Supreme Court has held in a recent judgment that the FIR is not a conclusive document with respect of MSCT claim. What is the paramount thing is that what evidence, oral or documentary, is brought before the tribunal at the time of adjudication. If the contrary evidence is produced before the tribunal, then the tribunal has to ignore the content of the FIR. And my case stands on a better footing for the reason that the informant was never examined in this case. And the insurance company has led no evidence. Rather, the claimant, my lords, may kindly read the.
Let us come to the evidence.
Yes, my lord. CW1, wife of the deceased.
She is not the eyewitness.
She is not the eyewitness, but I just want to read the paragraph 3 and 4.
Who is CW2?
CW2 is the co-worker. He was there. Yes, my lord. Paragraph 2. His name is Gopi Rai. Paragraph 2.
Yes.
कि मैं तथा मृतक नरेश चौधरी उर्फ नरेश पासी न्यू पूजा कैटरर के यहाँ खाना बनाने का काम करते थे तथा मैं तथा मृतक नरेश चौधरी उक्त कैटरर के अधीन पार्टी में खाना बनाने के लिए कतरास गए थे। काम से लौटने के क्रम में मृतक नरेश चौधरी उर्फ नरेश पासी उक्त ट्रैक्टर का कैटरिंग का सामान लेकर टाटा 407 जिसका रजिस्ट्रेशन नंबर सच एंड सच से लौट रहे थे तथा बाकी बचे हम लोग उक्त गाड़ी के पीछे एक टेम्पो से लौट रहे। तब दिनांक 9/6/2009 को भोर 4 बजे हरीक रोड काड़ा मारा पुल के समीप उक्त गाड़ी दुर्घटनाग्रस्त हो गई, जिससे गाड़ी में कैटरिंग के सामान के साथ सवार नरेश चौधरी नरेश पासी गंभीर रूप से घायल हो गए। नेक्स्ट लाइन, उक्त गाड़ी में चालक के अलावा केवल नरेश चौधरी उर्फ नरेश पासी सवार थे। दुर्घटना के बाद गाड़ी छोड़कर चालक भाग गया। मैं तथा मेरे साथ आ रहे लोगों ने जब दुर्घटनाग्रस्त गाड़ी को देखा तो उसमें नरेश चौधरी गंभीर रूप से गाड़ी में फंसे हुए थे। फिर उन्हें गाड़ी से निकालकर केंद्रीय अस्पताल जगजीवन नगर में भर्ती कराया, जहां इलाज के दौरान 16/6/2009 को नरेश चौधरी नरेश पासी की मृत्यु हो गई। नाउ पायलट, सो फार एज क्रॉस एग्जामिनेशन इज कंसर्न, और next CW2 again he is a co-worker.
Yes, I have understood this. Let us see.
So my case is, when I have led the specific oral evidence before the tribunal has committed an error by relying on FIR, which is not a piece of evidence in terms of Honorable Supreme Court's judgment in 2020-21 SCC online, page 849. The relevant is
What was the difference in the FIR and the
in FIR? There is a contention that there are 20-25%.
no, in that case which you are referring?
In that case, my lords, only 4 lines I will read that will clarify it. It is clear from the evidence on record of PW1 as well as PW3 that the SR van which was going in front of the car had taken sudden right turn without giving any signal or indicator. The evidence of PW1 and 3 is categorical, and in absence of any rebuttal evidence by examining the driver of the SR van, the High Court has rightly held that the accident occurred only due to negligence of the driver of the SR van. It is to be noted that PW1 himself traveled in that very car, and PW3, who has given statement before the police, was examined as not examined as witness. In view of such evidence on record, there is no reason to give weightage to the contents of the first information report. If any evidence before the tribunal runs contrary to the contents in the first information report, the evidence which is recorded before the tribunal has to be given weightage over the contents of the first information report. So,
This is PS case number. This was PS case number.
my lords, just a second. I am giving my lords.
Katras PS case number 144 of 09.
Yes, my lords.
लिखे तो?
My lords, charge sheet is already there.
Yes, I want to see the entire case diary. The principal district judge.
But may I request one thing, my lords? This was not the record before the tribunal.
Under order 41 rule 27, this court has a power.
Is always in power if the party make a request.
In Suamoto also. The court
can for the ends of justice.
Now, why I am also the case diary, the entire case diary of Katras, Dhanbad, Katras, PS case number 144 of 09. Corresponding to GR number 1715 of 2009.
It is 1715, my lord.
Yes, 1715. You know, Mr. Sinha.
Yes, my lord.
Because what is there in the FIR and what is there in the evidence, there is a huge discrepancy.
Yes. Yes.
Very well. The vehicle was not insured.
Vehicle was insured. The insurance company is here.
Yes, vehicle was insured, And uh, this can be a case where to wriggle out from the liability, because when the person lodges an FIR, it doesn't play in his mind that what are the legal consequences, which may later on happen in a corresponding cases. What has happened, he has narrated. Now, thereafter, when brains like Arvind Lal, Devesh Ghosh, Vibhas Sinha gets attached, they start cultivating that this will fail the collateral case. This statement, on basis of this statement, the collateral case will fail, so the liability will be so and so, it will be very difficult to get the money. So better change the case. Now, how much the case can be changed
Yes.
and whether the FIR is the very first version. The FIR is the very first version. And what is the reason to disbelieve the FIR? On facts, it has to be also seen. That is why I had called for the case diary to see whether there are any other injury report or not in the case diary.
Or my lords may call for the records of that GR case also. That what was the deposition before the
Not necessary.
criminal court.
And it may have been disposed without any evidence. Who will go there to give the evidence, most probably?
Yes,
I will call for the copy of the GR case records also.
yes. If my lord is of that view, therefore it may go against me. But I said that if
Now,
that is the evidence, then that is
if
evidence.
some evidence comes which supports the FIR,
Yes.
then I have to give a detailed judgment on the facts, differing with the judgment of the Honorable Supreme Court, and let Honorable Supreme Court decide also later on.
My clients are very poor; they can't go to the Supreme Court.
That is the
But that
reason.
is a sound ground to say that why this just Honorable Supreme Court's judgment will not apply, because
Will
the
not apply.
precedents always apply on
Yes,
foundational facts.
facts, absolutely,
Foundational facts.
absolutely.
One more thing, my lord, it
Yes.
has also to be seen that whether there is any violation of insurance policy condition or not. Because if the owner of the goods employee is also traveling in the vehicle, he cannot be termed as gaseous passenger and insurance company liable.
Now
147 section.
26, 25, 26%.
25 cannot be a representative. Of the
Very
Agree.
correct,
owner
my
of
lord.
the vehicle.
But on next day, I will try to satisfy you.
25% absolutely
Yes,
cannot.
my lord.
Entire evidence is beyond pleading, my lord.
But what
Yes, yes,
prevented the insurance company to put any question?
Beyond pleading.
Anyway, we are here to assist the
Let us
court.
see.
Let the records will come.
Let me see the
Real
record.
fact has to come.
Just for my satisfaction, I want to see the.
Yes, yes. And
Of
that is the
the
important thing. Yes. Obligement.
It makes no difference, my lord, in whose favor the case will go, result will go. But the real fact has to come.
Yes. Yes, next. List this case immediately on the receipt of the same. Let this order be faxed to the principal district judge Dharwad. It will come within a week, I think.
Yes, yes, my lord. Maybe just immediately after summer vacation, this matter will come up.
Maybe before also.
Okay. Obliged.
Serial number 41, MA number 530 of 15. Mr. Ashok Kumar Dev, Mr. Kumar Gaurav, Mr. Rahul Dev, for appellant, Mr. Ayush Aditya, Mr. Munna Kumar, Mr. Chandan Kumar Goswami for respondent.
This is an appeal for enhancement
Yes.
on two grounds, mainly two grounds. That future prospect not given,
Oriental, where is Oriental? Oriental Insurance. Who is appealing for Oriental Insurance?
I am informing Mr. Arvind Alok Lal. He used to appear for it.
No, who is appearing in this particular page one is to see. देखिए ना पूरा oriental की तरफ से. Discuss. Manish. Huh? Oriental Insurance. Kamal Prasad is Ayush Ashit Aditya Munna Kumar. Oriental Insurance Company received. There is no wakalatnama on behalf of Oriental. I am going expert, proceeding expert.
But I have informed Mr. Manish Kumar Malars. He's just joining. He also used to appear for Orient.
What is your ground, Mr. Counsel?
My lord, only two grounds, mainly two grounds are there. Future prospect not
Mr.
considered.
Manish Kumar has joined, Malars.
And
And second thing is
lord.
quantum.
quantum.
Learned Tribunal has taken notional income.
So
That
what
should
was
be,
what was the income of the deceased as per you?
this was a laborer. He was earned rupees 3,300 per month.
3,300 per month.
Per month. That itself is needed.
39,000 yearly. And the court has Mr. Manish Kumar, switch on your microphone.
My lord.
He's taking only two points. First ground is no future prospect granted. The award shows that there is no future prospect granted.
My lord.
Number two, the court has assessed his income as notional income 3,000 when there is evidence that he was a laborer, and he says that the claimant said that his income was 3,300.
Should have been taken through.
39,600 and 36,000. I think he's absolutely justified.
My
But
lord.
you have the file. But you don't have the file with you. Do you have
Yes,
the file? Your name also not appeared. On Monday?
Yes, Monday, my lords. Let it come on Wednesday, my lords.
Wednesday.
Yes, I'll assist your lordship on that date, my lords.
On 5th?
Yes.
Yes. List this case on 5th on the request of Mr. Manish Kumar, who undertakes to appear on behalf of the insurance company, as no one has appeared on behalf of the insurance company. That's in spite of service of notice. These are the only two grounds. It should be allowed.
Yes, but if possible, one copy at least, if he gives me, my lords.
Mr. Gaurav, give a copy.
Obliged.
Under the same heading. Under the heading for orders, under the Manish, under the heading for final disposal.
Yes, orders also.
Harding part under the heading for final disposal.
Yes. Obliged.
It will hardly make a difference.